Please close the door. Ma'am, you got a pad. हेलो मेरा मुझे दे दो एक. It's my immense pleasure that so many people have come. We were not expecting that much participant for this small event. It's one of our part of a series of a conference where we would like to generate a thoughts how to make India a better place for doing a business. So we received tremendous comments and suggestions how to promote arbitration in India. Even though we have seen several amendments in Arbitration Act over the various decades, but arbitration is not very popular mode of a dispute resolution. And it is said that you are adding another layer of a litigation. Once you file a case before a civil suit, so it can be appealed, but when we approach arbitration, they were run like a court and easily challenged before the court, and there's a same again issues. So how to make it popular, workable, and cost-effective mean of dispute resolution. So now I ask Mr. Ramasamy to inform you about the brief background of this research work, what we have compiled. And I think most of you have a leading question that have been done by our committee. So now I request Ramasamy to take over.
Thank you, Mr. Kaviraj. First of all, in fact, we are humbled to see this kind of a response. Ladies and gentlemen, thank you very much for sparing your time and being here. And sir, for you, a very warm welcome back to India. And for the members of the audience out here, Mr. Virendra Sharma represents British Parliament. So glad to have you here, and thank you, Mr. Lata Krishnamurthy, also for being here. We are still awaiting our chief guest, Mr. KTS Tulsi. However, without much ado, the idea, as rightly said by Kavirajji, the idea was that, we are at the cusp of creating possibly history in India. Already, the world economy looks at us as the only bright spot, what was even shared recently at Davos, where a leading economist said that India is a bright spot in today's otherwise uncertain world. Having said that, with Make in India and many other initiatives which the present government is taking forward from the previous regime, we thought it fit and proper that with so many amendments, changes happening, how to make business much more efficient, much more easier to do, and cut the layers in terms of friction, in terms of delays. So one of the topics why we chose about making India the next big place for arbitration. That's how we conceptualize this idea. I'm very happy to announce here that we rolled this out on 2nd of January 2016. Phenomenal response, more than 100 plus we got articles, cutting across from GCs to private practitioners to lawyers, from law firms. And we have tried to do justice to each one of them by having them posted on the website of our International Bar Association. We have also created a kind of a summary, which we'll be sharing with all of you post this event today. Taking a cue from there, we decided to have some leading questions, given the paucity of time and everybody being present here, of you all thinking out of the box and giving us solutions, including some radical solutions. Last minute I'll take, and I'll just say, crux of most of the suggestions that came our way, and I'll tabulate that, 6 or 7 points. The consensus which emerged was that, A, we need to establish one independent arbitration kept within rational limits to ensure that whosoever wants to go in for this alternative dispute mechanism feels that that's the right way of doing it. There should be constant focus on training. When I say training, training not only of the expert arbitrators, maybe the judges, including even the participants. We should go in for promotion of other alternative dispute resolutions called MEDAP. Government, media, Bar Council of India, we the public, and the private practitioners should also create awareness through various symposiums, seminars, hoardings, TV, any kind and every kind of social and other media. And most importantly, our own cultural mind shift in terms of, promoting arbitration should be on the forefront and not looked as another one way of, trying to address our dispute. Ladies and gentlemen, with that, I sum this up, and I'll just like to share with all of you that our program is limited to 1.5 hours of active deliberation. So may I request that when we go through the round table and we have the questions in front of us, each one introduces your name after putting on the mic and gives a crisp kind of a, your viewpoint so that it can be captured.
Yeah, not a very long introductions. Yeah. So please, everybody knows everyone over here.
And once again, on behalf of INBA and all of you present here, our humble thanks for making it.
Start the discussion.
Hi, thank you for this opportunity, and it's wonderful to be in the presence of all these esteemed people. My name is Lata Krishnamurthy. I'm a lawyer. I've seen this set of questions. They've almost done all of the work for us by setting down these questions. What is holding India from becoming a hub of arbitration in Asia? Obviously, it's the delays in the courts that is happening, and also the appointing retired judges as arbitrators. That's one of the main reasons. Is time ripe? Yes, time is ripe for India to have an arbitration nodal agency and to have one agency only, not the branch offices, but just one. This was something that was pointed out to me in the course of some discussion just now with Salami, and she's patented that idea, that it is not necessary to have branch offices, but to have just one central nodal agency with all kind of people registering there who have the expertise and who want to offer their services as arbitrators. They should be registered with that nodal agency so that directly they can appoint the arbitrators and we don't have to go to court under Section 8 to do that. How can the government or Bar Council of India help in objective of national so-and-so? They have to cooperate and promote arbitration by advertising it like he pointed out in the consensus. Tax disputes can definitely be decided by arbitration. Anyway, it's being done that way, but off the record, and private party gets the money, public government people get the money. So it's much better to have proper arbitration so that the entire amount goes to the exchequer. Do we actually require courts to supervise? You see, you cannot completely de-link courts from arbitration. That's my point of view, because at least for enforcement of the award, you need the help of courts. Supposing somebody gets an award in his favor and is unable to, get the other party to enforce the award, then, a nodal agency, does it have the power to send somebody to court, to jail, or to say that you must enforce or we attach your property? So there are some powers which are specific to courts. And those powers no other private agency can usurp. So when it comes to enforcement of awards or setting aside of awards, I think we may still have to fall back upon the traditional judiciary. Should arbitration not be dealing from it? Do we need a shift of focus? Yes, absolutely. I don't think retired judges should at all be there. We should have experts who are familiar with the subject and who are able to, give expeditious judgments because they understand the subject already. We don't have to be teaching them the basics of the subject before they are able to decide who is right or who is wrong. So therefore, it's important to have only experts. Does the new introduce amendments to arbitration? You see, the Act by itself, I'm afraid, has done something. It's gone back on what the Constitution bench has said. The Constitution bench has said the seat of arbitration should be the main thing. Now, they've diluted it and they've said that unless you have an agreement to that effect, it won't happen. It's good to have that Arbitration Act. It hasn't done any harm. But what is really the most important contribution of the present government, for which I applaud it, is this Commercial Courts Act of 2015, where they have tried to fast track the whole arbitration proceedings by saying that an order passed, they've created the court, you can go directly to the courts, that section 10 and 13, everybody knows, they've given a time frame before which it can be done. In 6 months' time, they say, once an appeal comes to you, please decide it. So all of that. So they have given a time frame, which is important. So and of course, all this will become irrelevant if we are going to have the dispute completely arbitrated. Then what further suggestions made by yes, to have experts, this commercial division should have experts and not the usual judges. So how do you pick them? They have to have the kind of public reputation and esteem that is most important for integrity. That would be important for them to be appointed. They should, in other words, have the qualifications of a judge with the expertise that is required in the commercial area, about which they should be so very familiar that things get speeded up. Will the newly enacted act, the Commercial Act, aid in the, progress of arbitration? Yes, it would. If we are going to continue with the traditional system of having to fall back upon courts, yes. But where we can definitely cut out courts' interference would be in the case of, if there is a nodal agency, we can cut out this, appointment of arbitrators can be done by them. And the second place where we can really cut out delays is when we go for interim reliefs. The arbitration tribunal itself should have the power. And once it gives an order, it should be binding at least till the arbitration proceedings are over. You shouldn't have an opportunity to go and, because aggrieved parties will immediately fall back on appeal. So that will again add to the delay. This is my immediate express reaction to the questions. Thank you.
I think now we should open the floor for inviting a comment. That will be better that if we follow a sequence, so we can start from here.
Thank you, Kaviraj. Honorable Member of Parliament, extremely honored to have you here. My name is Kapil Chaudhary. I'm the General Counsel for Autodesk in India, and I'm also a member of the Singapore Institute of Arbitrators. Very quickly, I won't take much time, just 3 to 4 points. Sir and respected audience, I had the honor of working in Singapore for the last 2 years while I was with IBM as a regional lawyer. And I have to share with you that in order to become a member of the Singapore Institute of Arbitrators, I had to sit for a 2-day classroom session morning till evening where the best arbitrators in Singapore came and taught me in a classroom environment. On a Monday morning from 9 o'clock till 2 o'clock in the afternoon, I had to sit in an exam and clear the exam. And it was only after I secured 85% did I get to become a member of the Singapore Institute of Arbitrators. The next step is to become a fellow and with equal rights of the fellowship with the Chartered Institute of Arbitrators in UK. I think this is India's opportunity. I think this is our time. We have the political will, Modi government. I think this is an opportunity which we cannot afford to lose. And I'll emphasize that this is our time. This is India's time. 1 or 2 things which we can do, let's follow and try to follow the Singapore model. Now, in Singapore, the interesting thing is you have an entire bouquet of services. If you want to do mediation, you can go to the SIMC. You want to do arbitration, you can go to SIAC. So the first step is let's join hands with Singapore. Why not we invite the likes of the SIAC chairperson, Gary Bourne, to come and help us set up a world-class institution like the SIAC. I want India to have the Indian International Arbitration Center today. We cannot wait. We cannot go to Singapore every time. We cannot go to London every time. With great respect to Singapore, they are eating our cake. We have the best of lawyers here, the best of judges here. I want to see arbitration by Indians in India now. I cannot wait any longer. I've waited far enough. So we'll invite Gary Bourne, we'll invite Toby Landau, we'll create the best. And companies like us, companies want to come to India and arbitrate. They tell me, where are the arbitrators? Where is the institution?
Kapil, I think you have made a point. We are exporting $1 billion business to the Singapore and London Arbitration Center.
Exactly. So I'll pass it on to Kadambari, but let's create the environment, let's create quality arbitrators, call them here, and they will come. Yeah. Thank you.
Your point is absolutely right. It's noted down.
Good evening, everyone. I'm Kadambari, a lawyer, and also a member executive of Delhi High Court Bar Association. I can see our friend from SIC all smiles because he's the recipient of the comments, of course, which are laudatory comments about SIC, and also our attempt to imbibe some of the features. So what I will focus on is the question whether this new act, whether actually it will pave the way for a better arbitral environment in the country. So this is what I say, although they have fixed a time frame for for deciding of the arbitration dispute, for appointment of the arbitrator and all of that. But once under Section 34, the time frame given firstly is 1 year, which is anyway too much, and the subsequent stages are not taken care of. So there's a High Court, Supreme Court, and as we all know, even those our cases languish over there for 4, 5, 6 years. So it doesn't really effectively cut down on the arbitration time. Secondly, the suggestion about one nodal agency ma'am had just given and which is incorporated in the paper. I feel that one nodal agency is specifically because there are so many institutions already which have been flourishing, which are flourishing in India, which are which have their own arbitral rules. Rather than that, I would suggest there should be a supervisory nodal agency. Instead of having multiple stages of appeals and so forth, there should be probably a judicial a semi-quasi-judicial authority, which can be the nodal governing agency, which can actually conduct those examinations as suggested by Kapil. There should be regular modules whereby some refresher. So you need to pass those exams so that there's a clarity that you still know the rules of procedure and so on and so forth. Then there is, in the Arbitration Act, there is a discretion given to the arbitrators to have their own procedure. I think the procedure should also be very set and defined. For instance, what you have in Delhi High Court Arbitration Center. It is very quick, and certain stages at the time of when you are filing your pleadings, the arbitrator is actually not even required over there. So that is cost-cutting way, cost as well as the time-cutting procedure. About the judicial review, as ma'am had said, can be totally dealing courts? No, because judicial review is the basic fabric of our constitution. You cannot de-link the judicial review in any case. A couple of points, if I have time, if Kabiraji allows me 1 more minute. There are a couple of things, basic contradictions in the Act itself, which I'd like to point out. For instance, Section 5 of Arbitration and Conciliation Act. There is a non-obstanta clause which says that no other court, judicial court, shall act upon or decide, adjudicate upon any matter relating to a thing which is covered by arbitration. However, Section 8, subclause 3, totally negates that, because it says that, yes, notwithstanding anything which is pending in any other judicial forum, the arbitrator can actually commence proceedings and go ahead and decide it. So there is a grave contradiction. Lastly, there is, of course, there is a clause for waiver, which is there when. Okay, so a lot of agreements in India are tainted because there is a named arbitrator. So one of the parties, which is the party which has the dominant role, will always enforce that their own person is named arbitrator. This is a very common practice in India. Here, while doing away with that, they have set up an elaborate procedure where the court can call upon the arbitrator to disclose if there is any conflict of interest, even with the counsel or the party. However, they have incorporated a waiver clause. So by agreement, the parties can actually waive off the right to object to impartiality or bias of named arbitrator. So I think this is very easy for the party who's in a dominant position to simply just say by an agreement that this will be the person, and the other party waives off its rights to object to it. So these are some of the observations, and I would not like to take on more time. Thank you. Thanks so much.
So please, you.
Thank you. Hi, good evening, everyone. My name is Pratik Joshi. I am a lawyer. I have a question with Lata ma'am. Ma'am, being a new kid in this fraternity, ma'am, my question is, how the judicial system can really help us out in developing the arbitration system?
What I would suggest, we can take a question after the first round of a discussion. Chance to speak.
Okay.
Script.
Okay.
Yeah, we looking for a suggestions, and
Okay.
answer will be the last one.
Okay. Yeah.
Hello. Hi, I'm from the Singapore High Commission. I should qualify that I'm not qualified as a lawyer. My experience is more on the policy side of things from the Ministry of Law. So just some general comments. There's a lot of interest in Singapore arbitration because we have that mass of cases with us. But our experience is that a lot of how we grew the center came from things external to the legal fraternity. It's about the business environment and our capacity to attract multinational companies to set up established presences here. And we are the headquarters for a lot of regional corporations. So it became a natural sort of location for the settling of business disputes and also other things like IP registration, like the development of financial services. So one perspective I could bring to this perhaps is that you need to look at the ecosystem. And this is a very high up the food chain, so to speak. You need a policymaker to look at this and follow through over the course of several years, because Rome was not built in a day, and so wasn't SIAC. So I'll just leave that thought with you, and I'll just let someone else take the comments. Thank you.
Thank you very much.
Good evening, everyone. Thank you to INBA and to the chair for granting me permission to speak. My name is Anant. I'm from Nishit Desai Associates. One disclaimer, Mr. Nishit Desai is on the board of SIAC. That said, I would like to make few comments, observations. I would like to make a distinction between improving arbitration, promoting arbitration as a dispute resolution mechanism, and promoting India as a destination for international commercial arbitration versus improving arbitration and court litigation in India itself. So I don't want to get into the Section 34 argument and all of that. I would like to talk about how can we get two European parties to come and litigate in India. How do we do that? First of all, we need better infrastructure, and by that I mean like good roads. It is horrible if you as a litigator or an arbitrator are stuck on D&D or ashram, something like that, and you can't make it for your arbitration conference. It sounds very trivial, but you don't find these, no matter what the traffic is in New York, Washington, D.C., London, Singapore, and I've been in all of these places, you will always make it to your arbitration. The second is attitude of litigants, and by litigants, for this I'm confining it to India. In India, whenever you litigate, there'll be at least one party who will say, protract the litigation, delay the litigation. Unfortunately, in India, even companies, including multinational corporations, do not have an attitude of resolving a commercial dispute and getting on with business. The fundamental objective of an Indian litigant in India is to protract it and say, do whatever you can, file a criminal complaint, get him to the negotiating table, then we'll see how we can resolve this. So two soft factors are the infrastructure and attitude of litigants. We've already talked about institutional arbitration. I think that will do a lot of wonders. Now, the second thing is, on hard factors, we need reciprocity arrangement with respect to both treaty convention and CPC for there to be enforceability, recognition, and things like that. Yeah. Just two more points, two quick points. Foreign lawyers arbitrating in India is a subject matter of litigation in the Supreme Court. Several times, Government of India, Bar Council have taken adjournments in that matter. Government of India said that they will amend the law and enable foreign lawyers, arbitrators to come in India for fly-in, fly-out arbitration. As long as you don't allow that, they will not be coming to India. We will not make India as a hub for international commercial arbitration. To promote arbitration itself, that attitude, if you make more disputes arbitrable, you remove the exceptions like fraud, this, that, and the other. You make disputes of antitrust, competition law, telecom, company law, all of this is arbitrable. You reduce the burden in courts. Court litigation is subsidized by taxpayer money. The minute you make it arbitrable, the cost of litigation is borne by the two companies who are involved. The minute you do that, court litigation, the burden on courts reduce, and you promote arbitration as well. And finally, only on the point that my friend made here on policy, taxation is a very big issue. The minute you have such an institution, Ministry of Finance, I'm sorry to say this, they will send a tax notice to this new arbitration center, so you'll need to deal with that as well.
Good afternoon, everyone. I'm Kavita Gupta, and I head the legal for Hitachi Consulting, especially the Asia Pacific region. And before joining Hitachi Consulting, I was with Wipro, wherein I used to handle the dispute resolution and compliances. The bad experience, I would say, I had with arbitration was delayed proceedings, hyper-technical, and lack of knowledge on expert matter. We used to get dates, like we preferred having, I would say the parties always preferred having judges, the retired judges, and we used to get dates, I think, once in 3 months, and sometimes the proceedings used to go for more than 2 to 3 years. So I would say that, yes, it would actually help, as Lata ma'am also mentioned, if we can have some timing, wherein we can set, like, the arbitration should be completed within this period. And it's good to have expert arbitrators trained in the technical field, like even the judges, like if we do have the judges, though the parties always prefer for judges, but it's really difficult to explain when it comes to technical matters, especially on IT industries, where sometimes they find it very difficult to get it. The other thing I would like to promote, which I actually picked up the concept from Singapore, is ARP, that is Arbitration, Mediation, and Arbitration. I think there should always be room for settlement between the parties if they want to settle, rather than pushing them. At the end of the day, we want a win-win situation. We don't want a party which lose or win and which actually ends the relationship. We want a continuing relationship, So that is, I think this concept will really help the parties, to get into a quick solution. And I would echo Mr. Anant's view on having arbitration on other sectors, especially on employee-employee relationship, whether it is anti-corruption, anti-bribery, or even on Competition Act. I think US do follow the system of settlement. And I think even we should also bring such system of settlement, or, so that we can expedite the process. So these are some of my quick views on arbitration. Thank you.
Thanks, Kavita. My name is Anupam, and thanks INBA for giving this opportunity for me to speak on this platform. I work for American Express, and I head the legal contract and compliance for the US market. Now, I will just take 2 points. I know with the Made in India campaign, the first and the foremost thing which we need to actually do is promote and awareness, and how we do that is it should come directly from the minister. And as Rama sir said, that it should be a various medium. I mean, it can be through radio channels, TVs, or promotional campaigns, so on and so forth. The other thing which I want to discuss is we need experts. And as Kapil stressed, I mean, he had to sit for a 2-day training and then pass an exam. I mean, we need experts in arbitration, and that is the only thing which can improve arbitration. The other thing is that the training should be imparted on a regular basis, whether it is the judges or the, just the pro arbitrators, or maybe even on the individual level as such. So I mean, just a couple of points, and I think most of the points suggested were very, very good enough. So I mean, I'll just pass it to my next fellow friend. Yeah.
Pauline, before going, we are getting a really good suggestion, but I would like to put one suggestion over here and a point to think. We determine and decide to go for arbitration. So dispute can be resolved only basis of the agreement, what they agreed, instead of applying a general principle of law, natural justice, and so many things. So just think about it. And another point I would like to raise is, they have a hearing for a 1 hour, 2 hour. So they can have a whole day hearing and on a continuous basis. So I would love your comments on these points as well. Thank you.
Sir, on that, okay. I would like to add on the, agreement thing, So the problem is our agreement is already running into 16 to 20 pages. And if we have an arbitration clause, if running to the one whole page, I think Kapil can add, the customer really gets worked out, and they want something which runs, wherein everything can be signed in 2 pages. So it's difficult to lay down the proceeding. The only thing that we look into is where is the place of arbitration, who is going to bear the cost, and what is the governing law. Apart from these 3 things, if we cannot write anything else, apart from, saying that it should be mutually decided.
In most of the contracts,
we will have a second round of, we still do this.
Thank you, INBA, for inviting me for speaking in this forum. I am Pulin Kumar. I am the General Counsel for Adidas India. And I will make a couple of quick points because most of the things have been covered, and I do not want to stand between the good hearing which we have and many people to know. But where the shoe is pinching, I will just touch upon briefly on that. See, what my suggestion is that, okay, framework is fantastically, conceptualized, but I go a little bit beyond that, and what is required here. Certainly, I would bat for the institutional arbitration, and not the ad hoc arbitration where mostly it lands up in an arbitration between lion and the lamb, which definitely I would not like. And first and foremost thing is that, in the institutional arbitration is the framing of the rules of the institutional arbitration. That's very important. It has to be so robust that it should cover everything. What I would prefer that the entire arbitration, institutional arbitration, we should have a complete and clear-cut advocacy to say that the policy document, where the dependency on the lawyers, because at certain point of time, the litigants, the parties are totally in the oblivion as to what is happening. Sorry to my litigant friends, my lawyer's friend. But we should also be a kind of, if we want to do the arbitration, we have, advocating for experts, we are advocating for, people who are really equipped with this kind of, peculiar nature of the disputes. We should have a clear-cut advocacy or the policy document which should, clarify the entire thing, where the litigant himself can participate in the conduct of the arbitration and get the desired result. I think that would reduce much timeline, and also it will save cost, which is the primary thing which pinches the shoes quite a lot. So this is what the understanding of we as a general counsel, in-house general counsels, and also we should have a multiple layer in the institutional that will of course be in the rules itself, where award is scrutinized, it takes the finality, the less amount of interference by the court. So these are the 3 quick points I would like to make it here, and this is what I would like to chair to take a note of this. This is where this shoe is pinching quite a lot, and we are facing the difficulties over there. Thank you very much.
Hi, good afternoon, everyone. My name is Sanjeev Ahuja. I'm corporate strategy consultant. So I see the wish list is getting longer, but we still. So to me, I'm thinking that why not, we optimally, look at a combination of a top-down and bottoms-up approach. Okay, so I'm just saying, the wish list seems to be pretty long, but we need to kind of, start from somewhere. So as a combination of top-down and bottoms-up approach, out of the list, I pick point number 3 and point number 8. So, and to me, the rest of it probably will fall in place in due course when we see the pressure coming from the top as well as from the bottom. So let's prefer the institutional arbitration over the ad hoc, which has been already said. And so it ensures consistency in terms of do's and don'ts, very important. And then the moment we have expert arbitrators coming instead of the current set what we get, with their diversified experience and exposure, so there'll be a pressure upwards to kind of make it more logical and merit based. So between these two, I think the lot of rest of the stuff will start falling in place. Thank you.
Good afternoon, everybody. I'm Pankaj Patel, heading legal for Future Group. Whatever has been said and done in respect of this arbitration, I have a very brief points to make. In an arbitration, I personally feel whether we have a credible arbitration institutions like CAC or LCI which is being conducted outside. Why? Because credibility is an important issue. Is unless and until we have that kind of a goodwill of an arbitration institutions, the foreign party does not resort to an institutional arbitrations in India. This is the biggest problem. That is the reason major chunk of the arbitration of an Indian dispute is also going outside India. That is one point. Second important point is basically about encouraging people to resort first to Indian institutions. Suppose if you encourage, if you mention that, if the arbitrations will be conducted in India, if through a policy or through a law also, if it is being encouraged, then the people will resort first to conduct an arbitration in India, institutional arbitration in India, rather than going outside India. And like in a divorce petition also, court also always tells that, first you sit and decide, before you file any petitions or before you depart. So first they should be resorting for a mediations. If they do not reconcile their differences within, say, 30 days or a 45 days, then they can go for an arbitration, because eventually arbitrator will also going to decide something which has a merit. An important point is the limited interference of the court. Why major chunk is going outside India is because the people are worried about that, in case if it is going into the Indian judiciary, then they will never be able to enforce their arbitration awards. So in case if the arbitration awards, if the finality of an arbitration awards being given in India, then the point is, and if there is a limited, means of course there should be a judicial review, I am not saying it should not be, but it should be very strict and limited, then that finality will help a lot. And as a duty of every general counsel, which I also feel when they are drafting the arbitration clause also, they should put a arbitrations wherein they should resort that, the first they should refer an arbitrations to in India. So in case if all the general counsels and the people, those who are sitting here, if they put a clause here that, they should first resort, try to amicably settle through a mediations, and if they resort to an Indian institutions of an arbitration, I think that will encourage. That work also has to be done from the industry side through the general counsel. Thank you.
Thank you, His Excellency, Kaviraj, Parveen, Lata, Ramaswamy, everybody. I am Rajiv Khanna. I am a law teacher. I am of the opinion that the Indian law of arbitration has to be totally revamped. Apart from the entry of foreign lawyers, we have to do away right now with the retired judges and even the chairmen of public commissions who are enjoying a fat salary of 3 lakhs per month, but allowed to do arbitration work, enjoying a beautiful bungalow in Luton's New Delhi area, enjoying all the perquisites. Nobody has spoken. Why? Only one competent to arbitrate. The time involved. And what about the appeal part? This law of arbitration should be parallel to our judicial system and within the judicial hierarchy. Sorry, no, it cannot be. The finality of the order has to be there. And if somebody wants, because of legal issues involved, he has to deposit to the, or pay to the other party at least 75% of the arbitral amount awarded to the other party. It has to be deterrent. Right now, 34 cases in the High Court are pending for the last 10 years. It's a matter of shame. It's disgrace. It's a heaven. Loot India. By whom? Due apologies? The judges as arbitrators? The lawyers. The claim is worth 10,000 crores, worth 15,000 crores, involving Indian companies and multinationals or two Indian companies. It's a reality. Government of India is the biggest litigant. Government of India is also one of the parties to these arbitrations. And what are they paying? 5 lakhs per hearing to the lawyer. For what? For delaying. Very purpose is delay. Very purpose of delay. The proceedings before the arbitrator come after 3 months. Why not, like the Indian judicial system, a court fee? Set fee be paid, irrespective of the claim. Where, irrespective of the claim, you file a petition before the court, the fee goes to the exchequer, whether the claim is of 100 or 1,000. Like motor accident, fixed fee. Marriage petition, rent petition, fixed fee. Accordingly, the fee has to be paid to the arbitrator, not by the parties, but by the institution which is controlling it. There has to be a nodal agency with expertise, like mediation centers in the High Court. Why not? Mediation and conciliation centers. There should be a nodal agency, and accordingly, it is due apologies as we are working. Economy has recovered, sone ki chidiya hai, loot lo.
Mr. Rajiv Khanna has been my teacher. Very well said. Yeah, our teacher as well. You have many students and disciple over here. So, Sarmaji.
Hello, I'm KK Sharma, and as for introduction, I will spend 25 years in the government, been Commissioner of Income Tax and DG of Competition Commission of India. Now I'm a practicing lawyer for the last 3 years. Much has been said, I will not repeat that. I would like to say that everybody is talking of institutionalization of this arbitration. For that, we have to have institutionalized practices. Here, we have to somehow limit the self-serving industry of retired judges, which everybody is talking about, where it sustains itself, it goes long, and it wants to continue. Secondly, we have to have set time limits for both the parties, set number of adjournments, come what may. You utilize or lose it. When people know otherwise in all arbitrations, there are two parties. One always wants to protect. Legal fraternity also helps that. One wants to finish it off. So unless there is an equal footing, nothing will happen. And you just ensure that those procedures are adhered to. As far as the supervision of courts is concerned, I'm sorry to note, they have to enforce the award finally. But because there are no time limits, and income tax there are time limits, nothing is pending. Everything gets finished. You have time limits, stick to them, but do not go the court's way, except enforcement of the awards. Thank you so much.
Yeah, I have one point to think over. Once we say time limit, Negotiable Instrument Act has a 6-month time limit. And if my learned friend allow me to say that CPC specifically does not allow any adjournment on the ground of at the request of your counsel is not available, or so many other grounds, but most allowed yeah, it's very became a rule. When your lawyer is not available, you are granted adjournment. So please think that, as said by the Singapore High Commission, that it's an ecosystem. We are a part of system, and we are also somewhere and some way are responsible for the failure of our own system. Thank you.
I would like to just respond. As a matter of fact, our system is very good. We
will discuss this. We will discuss this. Just.
Hi, good evening. My name is Salman Waris. I'm a partner with a law firm called Tech Ledges. I'm a specialized technology and IP lawyer. So I just wanted to make a couple of points. One is with regard to expert arbitration. I think especially in my area of work, we really need expert arbitration. And I have seen that in some of the arbitrations that I've been involved with, especially in the telecom industry. Unfortunately, the concerned arbitrator is either a retired judge or somebody from the government. They really don't understand the nuances of the issues involved. So we end up extending the time of arbitration. There are more adjournments. There's a more time taken to explain things to the concerned arbitrator. So I would really look for that maybe we would have more expert arbitration, and not only expert, but also specialized for maybe even for IP disputes. Mr. Anand is there, so maybe he can comment on that as well. And finally, I would like to really applaud the government for bringing about this amendment, the recent amendments, putting in timelines. I think that's the most important aspect. People go in for arbitration because they want the disputes to be settled quickly. Unfortunately, over the years, we had developed a culture where arbitrations had become more like litigation. So my, I think, suggestion would be that we should also develop a culture for arbitration where we give the people what they are actually looking at in arbitration rather than not just another extended litigation proceedings. Thank you.
Good afternoon, everybody. I'm Manish Bagga. I am from a non-legal background. I'm a business and a brand consultant. My comment will be non-legal in this regard. I would like to say that we are all a part of the society, and as far as litigation and arbitration is concerned, we need to address different strata of society at the same time. And we must use different mediums, technological, non-technological, advertising, all the mediums to go as far as possible in the society so that more people can associate with this thought of arbitration. We want to make India a hub of arbitration is what I understand. How do we approach somebody who is somewhere in UK or US or in Europe or in Japan and associate with this thought? We need some visual devices. We need some, maybe celebrity endorsements. We need, different aspects so that people can relate to this topic.
in the legal community, we can all understand.
Manish, what you're trying to say is the use of a technology. Through video conferencing, you can held a hearing through the video conferencing. No physical presence is required. That's what you're talking about.
Absolutely. So we should go to the last mile and understand that people need to understand that India is available, and India is available for a thought which is of international use or international, people can come into India and they can do it. So that's where, this thought comes in, that we need to bridge that gap as well. So one, creating a platform, one, communicating to the world that we are there. So my role is of communication. I can, that is also very important. Thank you.
Good evening. I'm Dr. Dimri. I'm from School of Law, Shada University. I've got a quick, point because I know the time constraint is it. Of course, the first point as regard to the institutional arbitration, much has been said as it. Of course, there's a need to have vis-a-vis ad hoc arbitration. We have to encourage the institutional arbitrations. There's no two ways. Now, second, about the Arbitration Acts contemplates we have to have the neutral arbitrator. So what happened, because when the disputes taking place where one of the foreign parties involved as it, so it will be better to give a semblance of neutrality as it creating, means to have a foreign arbitrator also should be included as it, so that we have inspire the confidences. Now, third points which I want to highlight is about Section 11, where the appointment of the arbitrator acts has not framed any rules whereby the arbitral proceeding can be expedited. So the court appoints an arbitrator, but what is to be done as it is not laid down as it. And it is better if the courts provide for the steps are provided to ensure that whenever the court is appointing an arbitrator, the court should also lay down the rule as to regarding first is what will be the issue which the arbitrator has to decide as a preliminary issue, particularly in relations to limitation and scope of arbitration. If a party files a claim which is either time-barred or outside the scope of the arbitration claim, then it should be decided as a preliminary issue, and heavy costs should be imposed on the party filing false claim in the arbitration proceeding. Now, the second is about the arbitration fee, and the time frame should be fixed by the court itself, because once it has not been appointed and the arbitration starts, it becomes difficult for the party to negotiate the fee with the arbitrator. Now, third point, the next point is regarding Section 13, challenge procedure of the arbitrator. It's very funny, because because a person cannot be judge of his own cause, very disputed. You're challenging the judge itself, So the power should be with the court, So if there is any doubt about the integrity of arbitrator or any of
excuse me, just we are running out of time.
No, just very small. Any doubt about the integrity of the arbitrator, any of the one party has apprehension that the party should have a right to take up the matter immediately with the court and not before the arbitrator. And the last point is it's about the online arbitration. Now what happened, this is in the case of a domain name disputes, this IN dispute resolution policy is overseen by the NICSI. So once the NICSI take up the matter, all these disputes are going online. So we can have that sort of the procedure.
Yeah. We will discuss it. Your point is not it. Vipin.
Vipin, just before you start, the idea of this roundtable is not actually to dissect the law, to come out with, points which can improve either the present system or overhaul the present system and make India a place where people will willingly want to come and participate in arbitration. So kindly keep that in mind when you, give us your points. Over to you, Vipin.
Hi, thank you. My name is Vipin Agarwal. I'm a lawyer. A lot of the points have already been discussed in the first half of the room. I think arbitration should be uniform across the country. It should not be, if you're having the case in Delhi, you sit after 4 o'clock for 2 hours and that's your session. If you have your case in Mumbai, you're sitting there from morning till evening, and your case might be done much, much faster. It should be uniform across the country. We should not have it as a benefit after the day is over. It should be your main day. We don't want to add another layer of litigation. Arbitration should not add to the parties' woes. It should help resolve them. Third, we should not have anything that is self-serving. for anybody, period. Okay? Arbitration is trying to avoid that. And finally, one size does not fit all. Okay? We have to recognize that there is a difference between mediation, arbitration, binding arbitration, and courts. And sometimes we think we can cherry pick, we can pick one, then the other, then basically go through it sequentially up till the very last step. And that's not what we're trying to do when we go through arbitration. Okay? And finally, I'd like to carry on with a point that was made by my colleague at the very beginning. This is $1 billion cake.